thanks everyone for joining. Obviously, the last panel was quite interesting, and exactly most of the same issues were discussed. But just wanted to, I think, start from where the last panel left. There is a lot happening. The government is trying to do a lot, especially with the new infrastructure finance secretariat that they have set up. And one of their key goals is basically to promote private investment, and they are actually going all out. And I know, as a law firm, which has never happened, we regularly get calls from, say, for example, Niti Aayog. We regularly get calls from the IFS, the secretariat, saying that why don't you all give us some points? What are your clients facing? Don't only give us the problems, please give us also how you want them to be solved. And they're really genuinely interested. And there are some very good bureaucrats and IAS officers really thinking about those issues. Obviously, there is a huge gap. Some of the issues which we discussed in the last panel discussion, no one wants to take the decision. I mean, unfortunately, that is how the government works. And again, having worked from the other side extensively, to a certain extent, we can sympathize with where they are coming from. Having said that, obviously, there's no excuse for things not moving and things just getting pushed to the courts. But the IFS itself, looking at capacity building, looking at knowledge creation, looking at the viability gap funding, how that can be improved. Obviously, viability gap funding has been around for a long time, but it has not been that effective. Some projects definitely we've been able to push through with viability gap funding. I mean, Sunay and I, in our earlier days, have done some very good VGF projects. But I think that needs to be pushed much more. Interaction between the center and the state, it's a big thing that needs to, and I think they are trying to push it, especially the central government, at least with the governments which are with them, with their governments around. But I just wanted to quickly do the first round with all of you. What, in your view, are the challenges that you're looking at? And keeping it very general, uh, obviously the three big things which I say, the three C's, certainty, clarity, and contract enforcement, it remains a challenge in India, definitely. But I would like each one of you to maybe start from your perspective. Sunay, from your side, from a renewable energy company side.
So yeah, thank you. The three C's you said are definitely still a challenge, uh, but a bigger challenge that we are seeing lately in the renewable energy sector is that the government's trying to address concerns of several stakeholders individually and one by one, which doesn't really work. What To give you an example, customs duty was imposed on import of solar modules. That was essentially to promote manufacturing in India, which we welcome. But a couple of big misses there were: one, the contracts that were already awarded were not safeguarded or grandfathered in a way. Because of that, all those projects got stuck. Even people who want to procure modules from within India, there is not sufficient capacity. So if it was a little transitionary in nature, it would have been better for the entire industry. Now, any investor who's coming in is coming with a horizon of when they want to put in the money, when they want to get out and recycle the money. But what this done is it's brought like increased that horizon by 2 to 3 years. Therefore, the sentiment from that perspective may not be that bright. The renewable energy sector, I think amongst all the infra sector is doing pretty well since the last few years, still attracting a lot of investment. But we need to give a lot of clarity to these investors now so that we don't lose this golden patch and the money doesn't get diverted.
So, Anjan, I'll just add one more C to the triple C's that we keep discussing. It's conflict. I think as a nation, we are looking at huge targets that we set for ourselves. So there need to be more players in the market. And especially speaking from an investor's point of view, we as investors are going to invest in more than one platform. And therefore, some of the conflict of interest clauses are just not going to work for us, right? So you can't say that, okay, if you're investing in one, you cannot invest in the other, because then there aren't going to be enough investors creating that pipeline of assets. So I think that C gets missed out a lot, and it's something which is going to sort of, in the immediate near future, going to become a big issue. Whether it's for players like CDPQ or for us, we would like to participate in more assets. And the second is, I think, creating the pipeline of assets. A lot of operating assets that we are seeing today changing hands, especially in the road sector, their history is 10 years old? Where is the next batch of huge assets coming in? So is really enough capital chasing or getting invested in greenfield infra? Because unless that is done, there won't be next set of pipeline assets for the operating players to come in. So there is less focus on that because of the inherent risks. And I'm sure we can get into those risks where investors are shying away from even participating big time in greenfield. And of course, we can get into whether equity, debt, and all of those things. But I think these two are the biggest concerns as investors that we see, and both need to be addressed immediately.
If you see the earlier documentation package which was there, they didn't even cater to things like asset under management, and the financial parameters were so much different. And even after these things being put in, I know multiple government authorities have no clue about what that means, how that needs to be addressed, and they are still stuck in that world of how they calculate the financial capability and the financial strength of a bidder. To that extent, you're absolutely right. And those documentation, at least those things, maybe at the IFS level, they need to look into it and standardize it across India, so that you don't need to tell each and every bureaucrat and every IAS officer what it means and how you should interpret it.
Yeah, like if you look at the SECI one versus the state one, right?
Yeah.
I mean, the language is so different. The state ones don't even talk about funds. They just say banks and financial institutions. Which era are we talking about?
Yeah, exactly.
These are not the players only who are in this sector, right? And the other one is a threshold of 10%. Yeah. I mean, 10%, and of course there's additional language of management and everything, but the thresholds are just too archaic and our targets are too aggressive. So we have to look at these things to be, amended super fast. We cannot any longer now have those bilateral conversations. This has to get addressed.
And like Sunay, you would remember initially when on these your concession agreements, we were trying to refinance them. There were no clauses in there. Absolutely. They only thought once financing will come in, through the life of the project, the financing will remain, and then it gets taken out by repayment. But there is no takeout financing concept. But yes, you're right. Those things have to be worked out. But Sunay, in your experience, we hear a lot about SECI, right? And how SECI is doing a good thing, and they are at least little better. Do you really think SECI has managed to do well? I mean, I keep hearing about the tripartite contracts and how SECI is at least trying to monitor with the standard documents and all of that. In your experience, what do you think?
So, in fact, Shagufa was talking about pipeline. We have the exact reverse problem in our sector.
Yeah.
Where there's such a massive pipeline that is not being developed on ground because of policy issues or regulatory issues, or because of delays on the common infra side, on the transmission network, essentially, which needs to come up. We have massive pipelines, but we're not being able to, and the threshold for entry in our sector is actually quite low. So it's easy for people to come in and apply money. We have the manforce, we have everything there, but we are still struggling to really implement it. SECI definitely, not only SECI, so all these intermediary players,
Yeah.
as they're called, SECI, NTPC, NHPC, and the like, they've definitely made it better from a recovery predictability perspective. We don't have to rely on the state discoms, not yet at least. I think till the time their balance sheet supports it, we are in safe hands. We are being able to recover money. The problems. So on that front, I would definitely say that this model is working for the time being, but they need to strictly implement the late payment surcharge rules that came out
Yeah.
recently. I think when they came out, a lot of discoms paid up their dues because there was a condition that they wouldn't be allowed to procure from the open market until they did that. So that was very helpful. But we're seeing that all of that is, declining again. They figured out ways to get out of that. So LPS rules need to be implemented very strictly. The central government has tried getting reforms in discoms quite a few times. I think they've had a little success, but still a long way to go. That needs to be fixed. Uh, what we are seeing is that there is also a push where like a B2B arrangement where IPPs can deliver power directly to customers. We are keen on doing that. But while there is a section of the government, probably central government and some state governments, which are allowing it and which are excited about it, at the same time, the discoms from the same states are pushing back. So I think a more holistic conversation is required, which is missing, where all stakeholders sit, understand what the concerns are, and then you push together in one direction. So we, as the management team in India, see ourselves as a bridge between the investors and the government, where we engage, we understand, what both sides want, and we try and implement it. But we are facing issues in terms of transparency or some sort of policy predictability of where we headed and what are the aims.
Rohit?
So I think since we are on C's, maybe let me add one more C. Corporate governance, which is maybe sort of a broader umbrella to what sort of Shagufa had talked about conflict, which I sort of 100% agree. For a sort of platform fund, it's a big problem if I suppose the right approach to deal with conflict is to find effective ways to manage it and legislate around that rather than it's almost as if if you have a cold you don't cut off your nose. So it's the approach needs to sort of move in that direction. So I 100% agree with Shagufa. On corporate governance, I think we've made tremendous progress, by the way. I think especially on the listed regime side, we are probably one of the jurisdictions which is far more advanced in many requirements that now come for sort of the top 250 companies or the top 500 companies. I think the challenge is, and I'm mentioning this because somebody in one of the earlier panels was talking about how corporate governance has sometimes been an issue for especially the roads and the highways sector. So I think the challenge is also finding that depth of talent. I think, as you can see, I think almost with every amendment, independent director's role keeps becoming more and more onerous. And it's very clear that there is lack of depth in finding those sort of capable individuals, because that is why you will see there are many who serve on multiple boards. They are in high demand. We have a cap on the number of boards you can serve on, and they are also pressed for time. This may not be their, usually it's not their full-time job. So coming for meetings, coming prepared, having the time and the bandwidth, and frankly the appropriate compensation for time spent to read the sort of quarterly updates or the management accounts and things like that. And I feel that's very important because you can have these mechanisms for effective corporate governance, but sometimes they only stay on paper, and they don't work effectively because, like I said, there's either sort of lack of depth in the market, or they're too onerous and people don't have enough time to sort of follow them. So it's sort of starts becoming like a check the box. I think if we can make progress on that as well, it certainly, I think the ideas are all there and they have been debated over many years, and we finally have all the right ideas. I think the practical implementation is sort of halfway there, but I think if we can cover the other half, then I think it makes for a very strong investment proposition, and especially for you know if you generally look at foreign investors, generally they know less about the market than a domestic investor. They generally know, they generally rely on second hand information. They work with external advisors. So these things have a sort of greater than proportionate effect on the confidence levels.
No, and in your experience, how do you see the dispute resolution mechanics? Because one very good point which was raised last time was the issue of finality, right? And see, at the end of the day, there is a reason why in our constitution we have the High Courts and the Supreme Court both being constitutional courts, right? And a school of thought, and which I think I do agree to a lot, is the Supreme Court not pushing enough onto the High Courts, or giving confidence to the High Court, saying yes, you are the last court, and I am not going to entertain things which keep coming to the. So in a way, what I'm saying is Supreme Court needs to hear less and not admit. Obviously, there's a reason why it's called a special leave petition and not a normal appeal which goes into the Supreme Court. But what is your take on it as an institutional external investor looking at India?
No, honestly, I think my take is exactly the same, what you articulated, and what sort of Sudipta was sort of alluding to in the previous session. And we've had this problem with any tribunals, administrative tribunals, land tribunals, electricity tribunals, any tribunals we've set up. It's a huge sort of drain on time, resources of the exchequer to set these up. They have been set up with specific expertise for specific industries. And unfortunately, from the tribunals, it goes to the high courts, and then it goes to the Supreme Court. And I remember this is a long-standing issue, even back, when I was in law school and I was doing one of my internships in the Supreme Court. And I remember, at least at that time, Mondays used to be sort of admission days for petitions. I don't know if that's still the case, but I remember there were few judges who were more progressive, and they would simply reject most of the 136 petitions and say, sorry, we are not finding a question of law here, which is, either two high courts are in conflict with, or, is of such grave importance that requires our intervention. And I think that's the right approach. It's absolutely fine for for a country to say that my final sort of court of appeal is the High Court. I don't think there's any problem with that. But that certainty is important to sort of come back to the first C you started with. That is very important, because when you have that, then I think parties are able to foresee better, negotiate better, understand their own positions better, and make commercial decisions sort of faster and better. So I think it'll also definitely cut down sort of the time taken to reach finality of a decision. Like I think Sudipta was mentioning, one decision which predates before she joined, and it's going to take at least 20 years. So no, I think I fully agree. I think high courts were by all means meant to be a final court of appeal for most matters.
Shagufa?
Let me just share, a couple of anecdotes from personal experience and not going into the details of the facts. But, despite the Supreme Court decision saying that the court should not interfere in bid outcomes, right? Because these are infrastructure projects and the delays are going to be costly for the public at large. Even till recently, you go through the process, you are selected as the bidder, the other party, the losing party, is going and filing the petition, and the court is giving dates. You shouldn't be doing that. In the end, yes, the outcome is what all parties knew from the beginning, that the winning party will remain the winner. But the entire process of just getting the court to even hear it went through 2 months. Now that's colossal waste of time, right? When as a court yourself, you've ruled that we will not interfere, then spend that half an hour, get it done with, and let parties go back and get the project started. And we've just been waiting. So, while the processes and all the relevant building blocks are there, but it's just that the abuse of the judicial system continues. And the courts and the judges are seeing that happen. So that I don't know how we will resolve it, because everything is rightly in place, but it's still the individuals who are misusing the system. And I think the other one is, I'm hoping the mediation bill will cause some of the commercial disputes get out of arbitration, because in arbitration you're sitting with retired Supreme Court judges. Not many of them are savvy enough to understand what exactly is the point of dispute in the calculation that has been done for the penalties. But we end up, in front of these Supreme Court judges, because the court to whom you've gone for hiring or engaging or appointing the arbitrator, the so-and-so brother, or, the retired judge who's in whatever ways maybe in good terms with the one who's appointing, gets appointed. And as a commercial party, you're frustrated because you're going to waste time to explain how the penalty is being calculated incorrectly, right? So I think there's fundamental attitude issue also. I think as investors, when we are coming into the country, and especially we are domestic fund, that we say charity begins at home, right? Governance begins at home. So if you are the losing party, you should say, I'm not going to litigate. Somewhere this has to stop. The attitude has to change. I think the system, the framework, a lot has got amended. The certainty to some extent doesn't happen because some of the other, most players themselves are abusing the framework. So I think that governance somewhere, the lens has to go back internally. We all should also start becoming accountable that we are not going to abuse the framework that is given to us. And just a little tangential point, I think, from a diligence perspective, when we were looking at, in fact, calling a cohort of speakers, and we tried to find women CEOs in the infrastructure space, and we found only one. So that's where I think, again, as investors, as institutional developers, we have to focus not only on the governance part, but the DEI part as well. Maybe we can pick up the ENS part, but I think a lot of focus on the board, I think that is sorted. But somewhere the management, why don't you see enough diversity at the management level as well, is an important issue, because all of this goes back to the quality of the management team, the quality of the asset that will come out. And we as investors want top quality, top management teams.
A slightly different point, which I see a lot in the infrastructure space, is you have the authority who is a shareholder, the authority who's an authority, and sitting and judging on issues, and coming to me saying, Anjan, how should I vote in a shareholders meeting? I said, who asked you all to take shareholding in the first place? Even with one shareholding, you could have got all those rights which you're looking for. You really didn't need to. And then you also have a clause saying that you can never sell those shares. Then why did you, even that you can't even monetize those. So, that these issues are, and you're right, these have to be taken up at I think at a larger level, at the institutional level. Sunay, what's your experience with the whole court system and?
Oh, not very good. But it takes up a lot of our time. We're talking about bid processes. There's a bid process where we were one of the successful bidders, and the authority chose to challenge the process, or rather just choose not to sign the PPA. that matter was finally resolved by the appellate tribunal after 2 years. And the funny thing is that the appellate tribunal said, okay, now you go back to the commission. The commission should consider what you were saying 2 years back and then decide. So I think the mediation bill is it's a good step forward. We are hoping that these authorities are empowered a little bit more to take calls which are black and white right in front of them. I also hope that there is some sort of a disincentive on state authorities to push everything to courts. In a lot of our conversations, they acknowledge that what they're doing is, they know what the right stand is, but they said, no, no, we will not take a call. We'll go to the commission. The commissions are not manned properly. So the dispute resolution structure within my industry is that there's a state commission, then there's an appellate tribunal, then you go to the Supreme Court. There are applications before the High Court pending at the same time. So it's quite a mess at the moment.
So if I may just add to your point, Sunay, that when you're saying that they're not making those decisions and they're tossing it off to the judiciary, I guess it comes from the fear of a CVC or a inspection investigation or whatever the CAG or everything that's looming over them over their heads. Maybe there should be some kind of a law which says that, okay, if the government is in business, or especially now most of our regulators are also sitting alongside us as shareholders, and there may be a business judgment rule that applies to them, that okay, in their business judgment that they're making this decision, and therefore they should not get challenged in the manner that they fear and they worry, and that's why cause delays.
No, absolutely. And in this space, actually, if you look at it, things are going backwards. Even not only the government companies or the PPP companies, even the private companies, if you look at it, and businesses can fail. And the kind of things that we are hearing with ED, SFIO, unbelievable. So it's not only now restricted only to the Sarkari Babus, but also coming to the private sector, which is very scary. I mean,
But so there's an example that is quite encouraging, which is the example of a dispute resolution committee set up by the central government for our sector. It's called DRC.
yeah.
It's a body which tries to resolve disputes between SECI and the likes and the IPPs without going to court. So they consider, and the order of the DRC is actually binding on SECI and the likes, which is very helpful. But we still have the authority to, we have the power to go challenge it.
Yeah.
But we've seen that's a step in the right direction, but it's not being utilized properly. I wish it's more matters are referred to it, and so on and so forth.
So you're right. In a lot of ways, when we talk to especially the central government, the Niti Aayog, the IFS, they are saying a lot of the things which are there. Some of it the private sector is not using. Some of it the state governments are not using. Right. For example, they keep referring to, and to be honest, I also for the longest time didn't know about the Specific Relief Act and the Special Court. Right, there is, and if you go back and read, there are provisions, there are courts which have already been sanctioned under that, but apparently it's not functioning. So there are things which obviously there is a gap, but this was one of the points which the IFS did point out to us the last time we were discussing with them, that how many of you all actually know about the special courts and their functioning, and if you look at what has been put, that you can have experts coming in, you can not put an injunction on a infrastructure project. So those are kind of step in the right direction. But I think it also needs to be done at a larger level. I personally feel amending the Specific Relief Act only doesn't help, but maybe looking at...
Just to add to your point on how private companies might be taking a step backwards, but in my experience, I've worked as an in-house counsel for the last 8 years now. The two companies I worked at, it was very clear that the metric for success for the legal team was not only how many cases do we successfully litigate, but also in how much time do we do it. Are we able to, prior to initiation of dispute, are we able to, give a sense of how long it will take, what the outcome could or could not be. So I think that made us very mindful of the disputes we initiated and we chose not to initiate. So that was good. And now we have decided to put in a mediation clause in all our agreements as a necessary step before we move on to arbitration or anything else. So I hope that
That's yeah.
makes it more efficient.
The other point where Shagufa you were mentioning, if you look at it, even with arbitration awards, they will keep appealing, so that I mean somewhere, and to be honest, even the private parties are doing it. It's not as if we can just tell the government that stop doing it. You have awards, you don't have the money to pay. What do you do? I mean, it is a difficult one, definitely, but. In terms of contracts, Rohit, we keep another big point that I keep hearing is we've always discussed unforeseen event renegotiations, right? And the government comes back immediately saying, "What do you think? What should be there in renegotiation, right? How much can you reopen?" Right, beyond the point, it's a business. You need to take that risk. Do you have any thoughts on that in terms of unforeseen events and things like where you were mentioning COVID, which is absolutely once in a lifetime kind of, and we still have COVID matters unresolved, right? How bizarre can that be? I mean, but it is still a reality. It is out there. What is your take on that?
It's a good question. Ordinarily, I think my answer to that question is, for sort of force majeure or sort of a material adverse change sort of clause, my sort of preference usually is for bright line tests, for objective tests, because then I think there is clarity enough for both parties. And then you are going in with your eyes open, and like you said, it's a business. You're taking a certain amount of risk, and that's maybe acceptable at some level. The reason I find it a bit more tricky for infrastructure contracts is because infrastructure, like sort of renewable energy, is ultimately a public good. I fully appreciate that the government and the other stakeholders, everybody needs to balance the interests of the general public versus sort of the private investor. Those interests can happily align on a number of things, and that's great. But yes, they can also sort of diverge. For example, on tariffs. You would obviously, from a general public perspective, the tariffs should always be super competitive, keeps energy costs low, which helps people sort of both in running businesses as well as sort of your daily needs. So I think it's a bit tricky for infrastructure contracts and energy contracts. They are much more long term. The issue with not having a bright line test for this sort of a clause is that again sort of if it's a subjective test, unless there is significant amount of jurisprudence on that and it's well understood, if they've used a particular phrase, what does that mean? Unless that is well understood, a subjective test will always be subject to whims and fancies, either of the counterparty, if it's a regulatory body, or of the particular judge if it's subject to litigation. So it sort of defeats the purpose, in my view, if it's a subjective test. But I think it's worth exploring to see, are there sort of objective tests that we can come up for infrastructure contracts, which are acceptable commercially, keeping in mind that it's a public good.
Shagufa, any thoughts on this?
So I think it will be tough to have objective tests, but I do believe that what hurts more is the delay in coming to an understanding of what it is, right? So I believe there should be a renegotiation. These are two long-term contracts. No party can actually predict how the facts will play out or how the project will play out if a force majeure event happens. So I do believe there should be a renegotiation, but in a time-bound manner. That is what is the issue, because here it just goes dragging on. There is no clarity, and at the same time, the project is suffering, the investors are suffering, and it becomes too late for any one of us to recover, whether us or the authority. So for me, the most important part is the time element. I'm fine with whatever test may be applied, but we cannot say, okay, it's cast in stone now. Too bad, it's a business risk. It can't be a business risk alone. It has to be, both sides have to take at least some sense of the impact of the event.
And I think you're right, absolutely. And I think more and more the foreign investors that we talk to, and when we are looking at a project, doing the due diligence for them, it is that time bound manner in which, I mean, there could be issues. Obviously, these will have issues. These are long term contracts. The other thing which we keep hearing is, they keep saying, Anjan, I can take the risk, but I need to know which way it's going. I mean, you can't tell me that it can go. I mean, and like in the last discussion we were having, I mean, we don't, as lawyers, we don't even know which, and all of us being lawyers advising business, we don't even know which way it will go. I mean, our Supreme Court itself doesn't. I mean, two benches of the Supreme Court are not seeing eye to eye. What are we going to say in terms of particular issue? That makes things much more complex. So I think in that overall scenario, time bound at least should be. I mean, my take on it is fight as you want to fight, but at least have a outer limit of the time, and let's move on with it, which is unfortunately not the case. So now in the renewable energy sector, mainly any large infrastructure sector, and we did touch upon this in the last session as well. Land, how much is that a key issue for you?
So land and modules, pretty much two key components of any project that we do. Land acquisition, because we've been doing it for so long, is predictable. But what the predictability is that we will have at least 30 to 40 cases that will go on throughout the term of the project. The revenue records are not very accurate. They're very badly managed. I don't think anyone can say with certainty which parcel of land belongs to whom, especially in the rural areas where we do our projects. But we've seen that these cases go on for a decade or more. They don't. Fortunately, we've not seen anything that has had a bad impact on the project per se, because we have diligence reports, we rely on government records, etc. But there is much to be done on that. Much to be done, and we see IPPs increasingly one relying on revenue lands, if possible. That's the best case scenario. Or secondly, or if you could possibly lease land. Sale is becoming something that everyone wants to stay away from.
Right. Coming back to your point, Rohit, in the last session, that's also, I think, something which is very important to, especially when we are talking of fostering investments, is the cost of capital here itself, and where the interest rates are going, and even when the interest rates are low by our standards, it's way high in terms of what the global market is seeing. Obviously, there are multiple factors, your country rating and all of it, and we've heard all of this for a long time now, and we've seen the government also trying to address it. I mean, though you have to stay within the framework in terms of the financings and the rate of interest that you can charge. What is your take on this?
I think on the interest rates, we are truly living in a sort of unprecedented time. Again, sort of, I think the last time the Fed raised, interest rates by, sort of 300 basis points or 350 basis points was when probably I hadn't started going to school. So we've never seen these sort of interest rates, and frankly, these are an aberration. In my personal view, these are an aberration. These are a fallout of the sort of tremendous disruption we've seen from COVID. COVID was a rare event which impacted each and every country, each and every economy, irrespective of which stage the economy was at, or how big it was, or what were its key sectors. So the governments obviously tried to do in every country what they could do best to support people during this sort of time of crisis, and now we are seeing a bit of a fallout of that. So I don't think, to be honest, I think the high interest rates at the moment are unfortunately a broader global macroeconomic phenomena, which I unfortunately is not just within the hands of the RBI or the Indian regulators to deal with. Having said that, my personal view is RBI has done a commendable job in sort of keeping interest rates in India in a fairly contained manner, managing sort of inflationary expectations at the same time. I am hopeful that these sort of interest rates are frankly unsustainable, not just in the long run, but also in the sort of medium run. So I'm quite hopeful, and my personal view is that these rates should come down. And once these rates come down, naturally the overall sort of cost of capital comes down as well. On sort of, I think the second part of the question, why it's sort of higher for India, like you said, credit rating of the country, the depreciation of the INR, those are again factors, but there's a balance there in the policy making. Depreciation of INR, which is sort of within a sort of bound, which is range bound, also helps frankly exporters in continuing to remain competitive. So I think when you start getting into a discussion on sort of INR depreciation and interest rates, unfortunately there are many sort of moving pieces there. So you have to be very careful. I think the policymakers have to naturally prioritize a number of things, and not all of them move together. So I think frankly that is something not in our control, I would say, almost. So unfortunately that's the world we live in right now. The good news is I don't think that can last very long. I think as sort of I again keep going back to sort of regulatory certainty, finality of decisions, enforcement of decisions. If all of that happens, the perceived risk of the jurisdiction goes down, and if that goes down, I think that helps sort of make investment decisions with more confidence as well.
I think the other thing which is very important, and which hopefully we will see some improvement, especially in the infra sector, is the National Bank for Financing Infra and Development, which is coming up. They're quite advanced. I think if they can manage to, because of their financing or kind of state government support with say soft loans, or looking at municipal bonds and all those, if you can keep the overall you might have components which are higher, but overall cost of capital in a project low, then obviously that does help. Soft loans, a lot of governments I know have looked at soft loans. I mean, we did a project in for government of Maharashtra, massive soft loan, and getting repaid. The government gets repaid after 15 or 20 years, and practically when they get repaid, they're not getting anything. But these are the ways that they can look at I think projects, especially in the infra sector, which is important. Just to wrap up, I think what I started with, and I'll come back to, and we genuinely get asked by, for example, Niti Aayog or IFS, what do your clients want? I mean, please let us know. I mean, if we were to give them 3 each from each one of you, what would it be? Shagufa?
So, I'll say this Urdu phrase, "Hazaron ख्वाहिशें ऐसी." So you're first of all telling us to bring down our asks to 2 or 3. So it's sort of linked to what we were just discussing and what Rohit was mentioning, and you also mentioned the cost of capital, right? We're talking about private investment into infrastructure, and let's look at the cost of capital for us versus a CDPQ. So we, of course, are working at a very high cost base versus the foreign investors who are able to manage to leverage abroad. So I think the first and foremost is, why is the insurance money and the pension money of India not coming into infrastructure? Right? If you look at the numbers, LIC plus the insurance companies put together is 600 billion. Look at EPFO and NPS is another 400 billion. We're sitting on 1 trillion. And I understand it's going to become 3 trillion by 2030. We have a demographic dividend. Nobody's withdrawing, so the assets are going to grow under their management. And the investment that they make into infrastructure is a fraction. It's an embarrassment of a number, right? So why is that private money not coming into infrastructure? And why is it that they're looking at only the risk-averse kind of investments, which is where the bonds and other debt kind of securities that they're investing in? So therefore, instead of looking at the interest rate, I think the biggest important aspect is for us to get that blend of equity, this kind of private capital, along with the institutional capital and debt. That is when we are going to be able to really take our infrastructure development forward. So my first big ask is, we need to get domestic pools of capital into infrastructure. We cannot rely only on the offshore. Our ambitions are such that we have to bring domestic savings into infrastructure. The second is, I think, again, a top one is blended finance. So we spoke about, you mentioned about the soft loans. I think what is being missed is that there are newer kinds of investors coming into the market. And I will speak selfishly from our perspective, which is AIFs. And as infrastructure AIFs, we have brought that stable institutional capital into the country. We've managed to raise institutional capital into our structures, but not enabling us to bring blended finance is again going to be a deterrent on infrastructure development. We cannot only get commercial capital, because all the investments are in INR. Rohit spoke about the depreciation, the factor that they add to the IRR that we have to give back to them. A 15% return on an infra assets consistently over a 10, 15, 20, 30-year infra fund is going to be difficult to achieve. So we need to get catalytical capital. We need to then bring the commercial capital. And for that, certain regulations, laws need an amendment. We cannot rely on the existing framework of FEMA, FCRA, or even the AIF regulations. Change is required. So I think the need of the hour is that we need to set straight the capital pack. I think I'll give you the top two. I do have a few more, but they will dilute the importance of these two important ones that we want.
So from our perspective, it's very urgent now that we are able to develop the projects that we have in our pipeline. That projects that we win, assuming that it'll come up in 18 months, have not even commenced construction. So we really need certainty on what the goals are. We need policies to be thought out, discussed transparently before they are implemented or rolled out. It takes up a lot of our bandwidth. If a policy comes out, we consider it, we make plans, and after 6 months or 1 year, we realize that it was actually nothing's going to happen. We saw that with the offshore wind policy, which probably came out 5-6 years back. Nothing's happened on it. I think we're still, again, talking about it, but we don't see a lot happening on the horizon. We are very hopeful on the green hydrogen policy. We really hope that the green hydrogen policy does not go down the offshore way, and there is actually some concrete plans to implement it. So that sort of certainty is something that will do very well for us.
Yeah, I know green hydrogen, they're trying to push a lot. Let's see how much they are.
And they're getting a very positive response from the players as well. Everyone's considering it, looking at it, even though the horizon's much longer than a generic renewable energy project. But we are hoping that all the effort that's being put in today will see something on the ground.
And you're right, Shagufa, that whole pension fund, Indian pension fund money needs to come out. I mean, sometimes it surprises me that I'm using Canadian pension fund, but I can't use my own pension fund in India for our projects. I mean,
that's true. And I would just like to tell Sunay that you're not alone. For us also in the financial services side, regulations just change too frequently. And we believe that, we've gone and explained it to the regulator, but we come back and then after a few months, there's a completely different circular that has come out. So definitely certainty is number one across sectors and the ways of doing business. It needs to get more simpler. We have still quite a few hoops that we have to go through before getting a transaction to its level of certainty that yes, we may be able to close this transaction. So I think the other thing is approvals. They do take a lot of time. So maybe with IFS, you should be taking up that as well. That while it's a sort of a consolidated center in that sense, but doesn't seem to be any influence on the turnaround time of the approvals.
They keep mentioning ease of doing business, but you're right. I mean, ground level, it's absolutely a very, very different thing altogether, especially if you get into the nitty gritties of a project, whether it's a project which is absolutely a greenfield project or a brownfield project, it's just unbelievable.
Correct. And add to that the legal risk, right? As in-house counsels, we are sitting and spending time with our deal teams, explaining to them, okay, yes, this is what I can, put my hand on heart and tell you would be the interpretation, but will it be there, down the line? I can't give you that kind of an assurance. So yes, please add another, a percent of, in your underwriting, because maybe there's not enough certainty that I can give you on this aspect. The legal risk discussions have really, got protracted in deal closure conversations internally.
Just to add one final point. See, I don't understand a lot of the finer details of financing and how money works, but I think one consideration that's definitely being left out is the trickle down effect that really a project of infrastructure project has. If you delay a project, it just doesn't impact the investor. Of course, it impacts the investor, but that money is eventually supposed to go down to the last person. I think that discussion is completely missing from the environment. It's not there at all.
The multiplier effect itself is such a
huge. And we were hoping that the regulators are mindful of this and the commissions are mindful of the impact these projects will have. But in any negotiation or a discussion or a matter, this point is not given enough time or value or consideration. I think that
Yeah, maybe just sorry. I realize we are running out of time, so just one quick thing. I think one of the other things, sort of more specifically, is I think just sort of various government departments talking to each other. If it's regulators at the center and state level, they talking to each other. Hopefully, I know this is a massive optimistic sort of ask, but I think for commercial contracts, it is possible, unless it's absolutely necessary for a state to have an amendment or for a state to depart from the sort of practice that everybody else follows. It'll be really good from our perspective to have a consistent approach. And for example, if I take just one example, for example, on road concessions, I don't know if GST is applicable, for example, right? And that's a big issue. And like you said, I think earlier, and like I think Shaguf also mentioned, nobody wants to take a call. At the end of the day, there is a CAG, there is various sort of regulatory oversight above bureaucrats. So it's all understandable, but I think it is important, and if a solution can be found for that, it can be beneficial to sort of everybody, the operators in the industry, the platforms, the investors, everybody I think will benefit from that.
No, I agree. And from my perspective, I think one, if I were to say, it would probably not to the government, but to the Supreme Court, saying, please keep admitting less matters. And you're right, it used to be done. Suddenly the courts have become very, very, I don't know what would be the reason. And with such a dynamic Chief Justice now, probably that is something which he should, and that's the easiest to do. I mean, it's just them sitting and saying, let's cut it out. I mean, why are we listening to these matters? And it goes on, you're right. I mean, one matter, they can't give you dates and the project is just lying out there, and you just need to decide on that SLP whether you'll admit or not. That itself takes 7 to 8 months, and then the matter goes on. Thank you.